Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
My name is Marty and I'm another one of the employment lawyers here at Devry, Smith, Frank. And a significant part of my practice is negotiating and settling wrongful dismissal claims. And we're going to be changing gears a little bit for my presentation. Today I'm going to be speaking about some of the employer's tax and repayment obligations when a wrongful dismissal claim is settled. Now, typically when a wrongful dismissal claim is settled, the employee is going to want the settlement funds allocated in such a way so as to minimize their tax liability. And at first, the employer may not really care because the employer may just think that all they have to be concerned about is how much money they're paying at the end of the day. But as I will get to a little bit later in my presentation, if the employer is willing to cooperate a little bit with the employee when it comes to allocating the settlement funds, the employer will actually be able to save some money too. Okay, so I'd like to go through some of the common ways in which settlement funds can be allocated and what the tax treatment would be. And I've also got a column here for some additional notes. You can't read everything at the back, not to worry, I'm going to be going through everything. The most common way of allocating at least some of the settlement funds is going to be as wages. And in the context of wrongful dismissal litigation, wages are also referred to as wrongful dismissal damages. It's really the same thing. And for any monies that are allocated as wages, the employer is going to be required to withhold payments for CPP, Canada Pension Plan, EI, employment insurance contributions, and finally for income tax. Another way that the employer may choose to allocate settlement funds is as a retiring allowance. Now, the Canada Revenue Agency defines retiring allowance as an amount paid to officers or employees when or after they retire from an office or employment in recognition of long service or for the loss of office or employment. Now, the employee doesn't actually have to be retiring in the colloquial sense to be entitled to a retiring allowance. So if you have, say, a 40-year employee whose employment has been terminated, and that employee is likely to get a job elsewhere before they retire, they could still be entitled to a retiring allowance as part of their settlement from the previous employer. And allocating money as a retiring allowance could actually result in the employee receiving more money tax-free up front, depending on the employee's annual salary and tax bracket. And this is because the employer is required to withhold monies from settlements that are allocated as a retiring allowance, but the withholdings are at these lump sum rates, which are 10% for amounts up to $5,000, 20% for amounts between $5,000 and $15,000, and then 30% for amounts for $15,000 and over. And significantly for settlement funds that are allocated as a retiring allowance, no deductions for CPP, EI, and income tax are required. It's just withholdings at these lump sum rates. So allocating money in this way is legal, and the employee may be happy because it means the employee could take some monies with less withholdings from the outset. Moving along, another way in which settlement funds can be allocated is general damages. And what we mean by general damages It's basically money to compensate someone for pain and suffering for things like bullying and harassment, breaches of human rights legislation, and other torts. Now, here are the rules for taxation of general damages. If the payment relates to the loss of employment, it is going to be subject to withholdings at the same lump sum rates for which withholdings would be required for a retiring allowance. If, however, the payment is for events that are unrelated or are separate from the loss of the employment, then these monies would not be taxable. So essentially, it's a but-for test. So if the employee was not going to get any money but for the termination, then it's going to be taxable. If the general damages are for events that are completely separate to and unrelated to the termination, then it's not taxable. So let's go through a few examples to illustrate this. So example number one, an employee alleges in a human rights claim that he was discriminated against throughout his employment based on religion. The party settled the claim for $15,000 and agreed to allocate the funds as general damages. This payment would be non-taxable because we're talking about events that arose throughout the employment, but there was no mention of any sort of discriminatory termination. So the $15,000 would not be taxable. Example number two. An employee alleges in a human rights claim that his employment was terminated in part because of his race. The parties settled the claim for $20,000 and agreed to allocate the funds as general damages. Withholdings on this payment at the lump sum rates are required because the payment relates to a termination, and but for the termination, the money would not have been received. And finally, example number three. An employee commences a civil action for damages sustained as a result of bullying and harassment that she faced in the workplace. The parties settled the claim for $30,000 and agreed to allocate the funds as general damages. This payment would also be non-taxable because there's no mention of a termination. It's related to events that are separate from a termination. So that's how we deal with general damages. I'll go through two more ways now that settlement funds could be allocated. One is to have a portion of settlement funds allocated for the employee's legal fees. Any money that's allocated for legal fees will not be taxable. The way this is dealt with in the Income Tax Act is by way of an income inclusion for the employee and then an offsetting deduction, so the net result is that it's not really taxable. If the amount requested by the employee or the employee's lawyer to be allocated as legal fees seems excessive, the employer could ask for a supporting invoice from the law firm and could even ask to have the employee sign an authorization and direction to have the settlement funds or that portion of the settlement funds allocated that way and paid directly to the law firm. And finally, often employees like to have part or all of the settlement funds transferred directly to their RSP accounts. And this is allowed as long as there is sufficient contribution room. And if this is done, then no withholdings are going to be required. The rationale for that is that the employee is going to pay tax once he or she ultimately withdraws the money from his or her RSP account. As I mentioned before, the employee needs to have sufficient contribution room in order for this to be done, and the employer should ask for the employee's notice of assessment to confirm this. The employee will have to provide his or her RSP account information to the employer so the employer can take care of the direct deposits. If the employer is still not really convinced that the employee has the contribution room in their RSP account that they're saying they do, they could also ask the employee to swear an affidavit which sets out all of the RSP contributions they've made in the particular year. And just a couple of additional notes on this one. It does have to be the employee's RSP account for this to work. It cannot be a spouse's RSP account. It can't be another family member's RSP account. And finally, in order for these settlement funds to be paid without withholdings, it needs to be the RSP account and not the tax-free savings account. It just doesn't work for the TFSA account. Okay, I'll move along now to one of the employer's repayment obligations when wrongful dismissal claims settle, and that's with respect to EI. So in the period between the employee's termination and the settlement, there's a good likelihood that the employee has received EI. And if the settlement includes an amount to be allocated as wages, which likely it will, and the employee has received payments for EI, this is going to trigger a repayment obligation on the part of the employer, and this is set out in the Employment Insurance Act. So if an employee becomes entitled to wrongful dismissal damages, for example, by way of a settlement, the employer must take steps to determine the amount of the repayment obligation and deduct it from the settlement payment. And for the case of EI, this is simply a matter of writing a letter to Service Canada to inform them that there's been a wrongful dismissal settlement, to ask for the amount of the repayment, and then the employer would simply withhold that amount and pay the money directly back to Service Canada. At the beginning of my presentation, I promised you a little bit of an example about how the employer could actually save some money if they're willing to at least partially cooperate with an employee when it comes to allocating settlement funds. So here's my example. Let's say we have a 12-year employee who earned $90,000 per year who sues his former employer for 24 months worth of wrongful dismissal damages and $50,000 in general damages for bullying and harassment. And the case proceeds to a mediation. And at the mediation, we're at the very end of the mediation, and the employee finally tells the mediator that he's not walking away for less than $45,000 net. In the other room, the employer tells the mediator that it's not willing to pay more than 8 months of salary to settle the claim, which would be $60,000 gross, including the termination pay under the Employment Standards Act. So the employer then does some math and calculates that if the $60,000 is allocated as wages or as wrongful dismissal damages, the withholdings for CPP, EI, and income tax would be approximately $20,000, so we're saying about 1/3. And if the settlement funds are allocated this way, the employee would only take $40,000 net, and based on the employee's demand for $45,000, the claim is not going to settle. However, if the employer agrees to pay 8 weeks of termination pay, which would be $14,000 gross, or $9,000 net paid to the employee, I'm assuming withholdings about 1/3, and then allocates $36,000 as general damages, which would not be taxable, then the case will settle because the employee would get his $45,000 net, so $9,000 plus $36,000, and then the employer only ends up paying $50,000, $14,000 gross for wages, and $36,000. So the employer was actually willing to pay $60,000 in this case, ends up saving $50,000, and the case settles. One additional note is that if the employer is concerned about the tax treatment of the settlement, the employer could include an indemnity clause in the settlement, which would essentially say that if the employer is hit up for more money in tax by the CRA, that the employer could come after the employee for that amount. In practice, whether the employer will actually do that is a bit of a different story. It's going to depend largely on the amount at stake, but it is a precaution that the employer could take. So in summary, there are many different ways that wrongful dismissal settlement funds can be allocated. It's important for the employer to understand the tax and repayment obligations and opportunities to save money. And finally, our firm can certainly assist you with your company's wrongful dismissal claims and in the process ensure that the settlement funds are allocated in accordance with tax laws. That's the end of my presentation. Thank you very much.
Thank you, Marty.